Okay, Gavin, thanks very much. I hope everyone can hear me. When I was coming here today, in the interests of economy, I thought I would get a Club 55 return from Lindsay to Dundee. Sorry, is that better? Yeah, I thought I'd get the Club 55 ticket from Lindsay to Dundee today to save Shelter some money, but I was quite disappointed when I got to Lindsay Station and asked for a return, because you're meant to take proof of age along with you, but nobody asked me for proof of age. Anyway, I'll stand up and do this. A man called Alfred Whitehead, who was a philosopher, said that the art of progress is to preserve order amid change and to preserve change amid order. And I've been asked to speak to you today about the changes you will find in the courts following the implementation of the new legislation, and I'm hoping that that is what the Scottish courts are going to be able to do: preserve order amid change and to preserve change amid order. One thing I should say at the start is no one exactly knows how the new Act will impact on current court business, but we've made some basic assumptions, and I'll let you know our best estimate of what we expect is going to happen. If I can take you through the impact on courts first, and then through the differences in court processes brought about by the new legislation. To start with the impact on courts, Section 2 and Section 3 of the Homeowner and Debtor Protection Scotland Act provide that all applications to court, in terms of Section 24 of the Conveyancing and Funeral Reform Scotland Act 1970 for recovery of property, and in terms of Section 5 of the Heritable Securities Scotland Act 1894 for rejection, shall be by summary application, which means that they will call in court on a fixed date. Now that sounds all terribly technical, and a copy of this handout will be available on the website, so you'll be able to pick it up in case you're trying to furiously take notes of all these different sections. As all repossession actions are not currently required to call in court, the Act will have an impact on court processes, resources and court time from the Scottish Court Service. In planning for the impact of the legislation on the Sheriff Courts, we have anticipated that although the most recent figures show that numbers may have peaked, we think that repossession cases are still likely to increase in the next year, and then expect them to fall off before steadying in 2012 to 2013, based on figures provided by the Council of Mortgage Lenders, which have of course changed since original estimates were made at the beginning of the process last year. However, the full impact of the increase in cases and the change in procedure is likely to be felt only in the larger courts. We anticipate that only 8 courts will face significant time increases, with Glasgow, Edinburgh and Hamilton having the greatest increase of anything up to 2 to 4 hours of court time per week. The other courts which are likely to be significantly affected are Paisley, Kilmarnock, Livingston, Airdrie and Kirkcaldy. Of the remaining 40 or so courts, from our recorded figures on mortgage lender actions, 7 courts dealt with less than 8 mortgage lender actions a week, including Dundee, and the remaining 34 dealt with 5 or less such actions a week. With only 50% of those cases or less estimated to be defended in court, the time increases in those courts is likely to have only a limited impact, with the majority facing time increases of around 10 to 15 minutes a week. So we hope. The increase in the number of repossession cases and the estimates of around 50% of defenders appearing in court is likely to be at the higher end of the scale. However, even if only a percentage of that figure is reached for cases being defended, taking account of the impact of lay representation, it is expected that court time will increase to some extent, especially in the larger courts. Now, dealing with the court process, as I said earlier, all repossession actions will now follow what's called summary application procedure. There are court rules which have recently been made, and they're called the Active Surveillance Sheriff Court Rules, Enforcement of Securities over Heritable Property 2010, and that's available on the website if you want to have a look at it. And the rules have added a couple of steps to the process. The rules state that the pursuer must include averments in the initial writ. The initial writ's the initiating document. That the pre-action requirements in terms of Section 24A of the 1970 Act or Section 5B of the 1894 Act, as amended by the new Act, have been complied with, and in addition the pursuer must lodge a form, the form is called 11C, certifying the completion of the pre-action requirements when the initial writ is lodged in the Sheriff Clerk's office. This will require the pursuer to tick a box stating that each of the pre-action requirements have been met, and also provide details of how that has been done. The Sheriff Clerks will check that the averment is included in the initial writ, and that the form is lodged and that each of the boxes has been ticked before fixing a hearing and signing the warrant of intimation. The detail of how the pre-action requirements have been met will be a matter for individual sheriffs. Some may take the completion of Form 11C at face value. Some may examine the detail of what the pursuer has stated on the form at the first hearing, whether or not the defender is present. If the defender does wish to challenge anything in the Form 11C, then this is their opportunity to do so at the first hearing. The summary application procedure will mean that a hearing is fixed at the warranting stage, so that when the initial writ is intimated to the defender in the first instance, it will give the date and time of the court hearing. The rules also provide that where a defender opposes an application, which he can do during the appearance at the first calling in court, the sheriff may order, and I emphasise may order, formal answers to be lodged within a specified period, and at that stage, in these cases, it is also likely that a proof hearing will be fixed for a later date. If written answers are required to be lodged, there will be a court fee of £80. The summary application procedure is, as the word summary suggests, a far less formal procedure than the previous ordinary procedure, and written defences or answers are only required if the sheriff orders them to be lodged. In many cases, the defender may turn up at the first court hearing, but that may not always be to state a defence to the action, but may be simply to advise that they're looking for some further time to remedy the default by paying the arrears, or for example to organise alternative housing provision. There is no court fee charged for the first appearance. In these cases, the court may simply continue the case to a further hearing to allow matters to be settled before granting decree or dismissing the action. The main concern for the courts is what is known as churn, and it's got nothing to do with making butter. This is when cases are continued on more than one occasion and reappear on the court roll many times, taking up court time without a conclusion ever being reached. This is considered to be a waste of judicial time, and is not a good use of public funds, and simply uses the sheriff to act as a sort of watchman in proceedings. If this happens in a significant number of cases, the delays in allocating hearings to consider new cases may increase significantly. Currently, the period for fixing a first hearing in Glasgow and Edinburgh is 6 weeks, and it certainly wouldn't be any more than that, and indeed probably less, and it's hoped it will be able to maintain that 6 week period. Where a defence to the action is stated and a proof hearing is fixed, a court fee of £45 will be charged, and a further fee of £95 for every day or part day of court time the proof takes will also be charged. These are equivalent to the fees currently being charged under ordinary cause procedure, and the expenses will usually be classed as expenses in the action, and when decree is normally granted, will be paid by the person who is unsuccessful, or the loser, if you like, in the action. The rules of court also contain provisions that deal with intimation to known entitled residents, applications to the court by entitled residents, which must be in a prescribed form, and provisions relating to recall of decree, which is also by completion of a prescribed form. Recall can only be lodged where there is no appearance by or for the defender at the earlier stage in proceedings. The other change which impacts on the court process is the introduction of a lay representation. Going back to the Repossessions Group final report, which was published in June 2009, it said that it would be helpful if experienced providers of lay advice and representation were allowed to play a larger role in helping unrepresented litigants in the court process. Section 7 of the new Act follows the group's recommendation and allows the debtor or entitled resident to be represented by an approved lay representative in court proceedings in relation to a creditor's application, including recall proceedings under Section 6 of that Act. Previously, in repossession proceedings, there was a limit as to what non-solicitor advisors could do. The only individuals with rights of audience to represent and participate in the proceedings were solicitors or, on very rare occasions, advocates. The provisions in the new Act mean that lay representatives also have the rights of audience, same rights of audience as solicitors, so that any debtor or entitled resident involved in these proceedings can have a lay representative acting for them if they so choose. A lay representative is defined as an individual, other than an advocate or solicitor, approved for the purposes of Section 24(1)(b) of the 1970 Act or Section 5F of the 1894 Act by a person or body prescribed, or a description presented in regulations. Sounds very complex. The definition of a lay representative in these terms protects the debtor or entitled resident and ensures that court business proceeds smoothly. Only individuals who have the appropriate skills and knowledge to understand the proceedings and to represent individuals effectively should be approved to act as lay representatives. Someone who does not understand the relevant court proceedings is not likely to be able to represent the interests of debtors properly in court. Other people, such as a friend, spouse or colleague, can in some instances attend court proceedings to support individuals, but this is distinct from the active role of the statutorily defined lay representative, and they will not have rights of audience to participate in repossession proceedings on behalf of the individual. Secondary legislation prescribes those persons and bodies which may approve lay representatives. Sections 712 and 722 of the Act require lay representatives at any point throughout the proceedings to satisfy the sheriff that they are a suitable person to represent the debtor or entitled resident, and that they are authorised to do so by the individual and they are approved by the prescribed body. In Glasgow and Edinburgh, it's expected that the lay representative will be able to produce a letter of authorisation from the approving body that they can produce to the sheriff if he asks to see it. One thing I should say, quite importantly, is that the Act does not confer an automatic right on debtors and entitled residents to lay representation, nor does it mean that an approved lay representative is obliged to participate in all proceedings. Prescribed bodies approving lay representatives should ensure that those individuals approved to act are aware that the sheriff is responsible for ensuring efficient use of court time. This means that if the sheriff considers that the lay representative is not a suitable person to act on behalf of the debtor or entitled resident, then the sheriff may discharge them and they will no longer be able to take part in the hearing. Lay representatives should, on arrival at the court, advise the clerk of court or court officer of their attendance. And in Glasgow and Edinburgh, they will be expected to go straight to the court as directed and advise the court officials that they are present. In my experience over the last 38 years in the court service, courts generally welcome any assistance which experienced lay representatives can give to the court to make better informed decisions. And I am sure that lay representatives will be well received in the sheriff courts in Scotland. To go back to my original quote, the art of progress is to preserve order amid change and to preserve change amid order. And I'm hopeful that that's what Scottish Court Service will be able to do. Thank you very much, ladies and gentlemen.